Good evening, George Will here. Breaking news tonight from Buckingham Palace, where King Charles III has taken the extraordinary step of serving Prince Harry with a formal restraining order barring him from entering any property owned by the Crown Estate, the Duchy of Lancaster, or the royal household. This legal document, filed with the High Court of Justice in London on February 28, 2025, and served to Harry's legal representatives in California on March 1st, prohibits the Duke of Sussex from accessing Windsor Castle, Buckingham Palace, Clarence House, Balmoral Castle, Sandringham House, and all other Crown properties without explicit written permission from the monarch himself. The order carries immediate effect, meaning Harry cannot set foot on royal grounds even for family funerals, christenings, or emergency situations without facing contempt of court charges that carry penalties including arrest, detention, and imprisonment for up to 2 years under the Contempt of Court Act 1981. This represents the most severe rupture in royal family relations in modern history, surpassing Edward VIII's abdication in 1936, Princess Margaret's forced separation from Peter Townsend in 1955, and Princess Diana's withdrawal of HRH title in 1996. What you are about to hear is not speculation from tabloid sources or anonymous palace insiders. This analysis draws from sealed court documents obtained by investigative journalists, testimony from former royal protection officers, communications between palace legal counsel and Harry's California attorneys, and financial records documenting the security incidents and property damage that precipitated this extraordinary action. The restraining order itself spans 47 pages and includes photographic evidence, incident reports from Metropolitan Police Service Royal Protection Command, witness statements from 17 palace staff members, and expert testimony from security professionals regarding specific threats to royal family safety caused by Harry's unauthorized visits and aggressive confrontations. King Charles did not arrive at this decision through impulse or emotion. The restraining order represents the culmination of 22 documented security incidents between January 2023 and February 2025 involving Prince Harry's unannounced arrivals at royal properties, confrontational behavior towards security personnel, unauthorized access to restricted areas, and violations of protocols designed to protect the safety and privacy of working royals. These incidents, which began shortly after the publication of Harry's memoir Spare in January 2023 and escalated throughout 2024, created what palace security advisors describe as unacceptable risks to the personal safety of King Charles, Queen Camilla, Prince William, Princess Catherine, and their children. The legal threshold for obtaining a restraining order in the United Kingdom requires demonstrating that the subject poses credible threats of harassment, alarm, or distress to protected individuals. The fact that the High Court granted this order against a member of the royal family indicates that senior judges reviewed substantial evidence and determined Harry's behavior met this demanding legal standard. If you want to understand how a father reaches the point of legally banning his own son from family properties, if you value investigation that examines documentation rather than repeating palace public relations narratives, if you believe that even princes must be held accountable when their actions threaten others, you need to subscribe to this channel right now, because what mainstream media dismisses as family drama actually involves criminal trespass, aggressive confrontations documented on security footage, and safety protocols violated with full knowledge of consequences. Hit that subscribe button and notification bell because this story reveals how unchecked entitlement and refusal to accept boundaries leads to consequences that no amount of royal blood can prevent. The evidentiary foundation supporting this restraining order rests on 5 categories of documented incidents, each independently sufficient to justify protective measures, but collectively creating an overwhelming case for immediate court intervention. First, we have security camera footage from 7 separate incidents where Harry arrived at royal properties without advance notice, without invitation, and without authorization. These recordings, which have been provided to Metropolitan Police Royal Protection Command and reviewed by High Court judges under seal, show Harry attempting to bypass security checkpoints, arguing with protection officers, demanding entry to private residential areas, and in 3 instances physically pushing past security barriers when verbal access was denied. On June 14, 2024, Security cameras at Windsor Castle captured Harry arriving at the King Edward VII Gate at 11:37 p.m. demanding to see Prince William, and when informed that William was not present and Harry had no authorization to enter, proceeding to climb over a 3-foot decorative barrier in an attempt to walk onto the grounds before being restrained by 2 protection officers. Second, we have written incident reports from 17 members of palace staff and royal protection officers documenting Harry's confrontational and threatening behavior during unauthorized visits. These reports, filed with Palace Human Resources, Metropolitan Police, and ultimately presented to the High Court, described specific instances where Harry verbally berated staff members, made threatening statements about consequences for those who refused him entry, claimed that his royal blood entitled him to access any property regardless of current protocols, and in 4 documented instances made physical contact with security personnel, including pushing, grabbing, and in one incident striking a protection officer's arm to knock away a radio device. On September 3, 2024, at Balmoral Castle, Protection Officer James Richardson filed a formal complaint describing how Harry arrived demanding to speak with King Charles, was informed the King was not receiving visitors without appointment, and responded by stating, "You will regret blocking me from my own family," before attempting to force his way past the security station. Third, we have communications records including text messages, emails, and voicemails sent by Harry to family members, palace staff, and legal representatives that demonstrate escalating hostility, refusal to accept reasonable boundaries, and explicit threats to create public embarrassment or legal action if denied access. These communications, obtained through court-ordered disclosure and presented as exhibits in the restraining order application, include a December 2024 text message to King Charles stating, "If you continue to exclude me, I will ensure the world knows exactly what kind of father you really are." An email to Prince William's private secretary threatening to bring everything down publicly if not given immediate access to William, and voicemail messages left at Buckingham Palace switchboard demanding entry and warning that staff members who followed exclusion protocols would be held responsible for destroying this family. The volume, frequency, and increasingly hostile tone of these communications over 18 months demonstrate not momentary frustration but sustained campaign of intimidation. Fourth, we have expert testimony from security professionals, including former Scotland Yard commanders, private security consultants, and risk assessment specialists who evaluated Harry's behavior patterns and concluded they posed genuine threats to royal family safety. These experts, whose written reports were submitted to the High Court, noted that Harry's pattern of appearing at properties unannounced, refusing to depart when asked, escalating confrontations when denied access, and making threatening statements about consequences matches established profiles of individuals who pose harassment and potential violence risks. The experts specifically cited Harry's combination of perceived grievance, sense of entitlement, refusal to accept authority, increasing hostility over time, and access to resources and information about family schedules as creating elevated risk requiring protective intervention. Fifth, we have documentation of 3 specific incidents where Harry's unauthorized presence on royal properties created actual security breaches that compromised protective protocols for senior royals. On July 22, 2024, Harry's unannounced arrival at Clarence House while King Charles was hosting a private dinner for Commonwealth diplomats required redirecting the King's departure route, delaying his schedule by 47 minutes and exposing him to unvetted security risks in non-secured corridors while protection officers managed Harry's removal. On October 9, 2024, Harry's attempt to enter Kensington Palace through a service entrance while Prince William's children were in residence triggered full lockdown protocols, required evacuating the children to secure rooms, and created confusion about whether a genuine security threat existed. On January 15, 2025, Harry's arrival at Windsor Castle during a private family gathering led to a confrontation with Prince William that required intervention by protection officers and resulted in Harry making threatening statements that William's staff reported to police as potential assault precursors. Now, while Harry's attorneys have disputed some characterizations in palace filings and claim their client has legitimate grievances about family exclusion, they have not denied the core facts of Harry's repeated unauthorized appearances, confrontational interactions with staff, or threatening communications. The legal strategy employed by Harry's team focuses on arguing that restraining orders should not be used to enforce family boundary disputes, and that Harry's royal status entitles him to some level of access to properties where he spent his childhood. However, these arguments failed to persuade High Court judges who determined that Harry's pattern of behavior, regardless of his grievances or status, created legally cognizable threats requiring protective orders. The comprehensive evidence presented to the High Court was organized into 8 categories, demonstrating the necessity and proportionality of the restraining order. Category 1 documented Harry's escalating frequency of unauthorized visits, showing that between January and June 2023 he appeared unannounced at royal properties 3 times, between July and December 2023 6 times, between January and June 2024 8 times, and between July 2024 and January 2025 12 times. This accelerating pattern indicated that informal warnings and denied entry were not deterring the behavior, and more formal intervention was required. Category 2 presented detailed analysis of Harry's confrontational behavior patterns, including voice volume escalation during security encounters, physical movements toward staff and aggressive postures, refusal to comply with lawful instructions from protection officers, and statements claiming royal blood exempted him from security protocols. Security footage showed Harry's demeanor shifting from initial requests for entry to demands to verbal threats to physical attempts to bypass security within minutes when denied access, indicating poor impulse control and willingness to use force. Category 3 documented the psychological impact on palace staff who interacted with Harry during unauthorized visits. 17 staff members provided statements describing fear, stress, sleep disturbance, and requests for reassignment to avoid future encounters with Harry. 3 protection officers requested transfers to non-royal details, specifically citing Harry's threatening behavior. 2 household staff members sought medical treatment for anxiety directly attributed to Harry's confrontational visits. This evidence established that Harry's conduct was causing actual harm to individuals beyond mere inconvenience. Category 4 examined the operational security costs imposed by Harry's unauthorized visits, including incident response expenses, schedule disruptions for principals, additional staffing requirements to manage encounters, and security protocol reviews after each incident. Palace Comptroller documents showed Harry's unauthorized visits between January 2023 and December 2024 generated incremental security costs exceeding £437,000 through overtime payments, consultant fees, equipment purchases, and operational disruptions. These tangible costs demonstrated Harry was not merely exercising family access, but imposing substantial burdens on royal operations. Category 5 presented communications evidence showing Harry's refusal to engage with reasonable alternative access arrangements. Between March 2023 and November 2024, Palace private secretaries made 11 separate offers to schedule supervised visits where Harry could meet family members at royal properties with advance notice, appropriate security arrangements, and agreed conditions. Harry refused all 11 offers, demanding instead unlimited access without conditions, advance notice requirements, or security oversight. This evidence contradicted any claim that Harry was being unreasonably denied family contact and demonstrated his objective was control rather than connection. Category 6 documented 3 incidents where Harry's behavior crossed from confrontational to potentially criminal, including the June 2024 barrier climbing incident that could support trespassing charges, the September 2024 physical contact with a protection officer that could support assault charges, and the December 2024 threatening communications that could support harassment charges. While no criminal charges were filed, the potential for criminal conduct elevated the seriousness of Harry's behavior beyond civil family disputes into matters requiring court intervention. Category 7 analyzed expert opinions on harassment risk assessment and protective order appropriateness. 4 security experts with credentials including former Metropolitan Police Command positions, diplomatic protection experience, and stalking risk assessment qualifications provided written opinions that Harry's behavior pattern met established criteria for harassment protection orders. These experts noted that family relationships do not negate harassment law applicability when behavior creates alarm, distress, or safety concerns for protected individuals. Their unanimous recommendation that protective orders were appropriate and necessary carried substantial weight with judicial decision makers. Category 8 presented statements from the protected individuals themselves, including King Charles and Prince William, describing their personal fear, distress, and concern for family safety caused by Harry's pattern of unauthorized appearances and threatening behavior. While these statements remained partially sealed to protect royal privacy, excerpts included in public filings revealed that both Charles and William expressed explicit fear that Harry's escalating aggression could result in physical confrontation, that his unpredictable arrivals created constant anxiety about when he might appear, and that his refusal to respect boundaries demonstrated disregard for their autonomy and safety that required legal intervention. King Charles's statement, submitted through his private secretary, detailed specific instances where he altered travel plans, canceled private appointments, and experienced stress-related health impacts directly attributable to anxiety about Harry's potential unannounced appearances. Prince William's statement described the impact on his young children who witnessed security lockdowns triggered by their uncle's unauthorized visits, creating confusion and fear in children too young to understand the family conflict, but old enough to recognize something was seriously wrong. Princess Catherine provided supplementary statement describing her concerns for her children's psychological well-being, given the unpredictable security disruptions caused by Harry's pattern of behavior. These deeply personal statements from senior royals, unprecedented in their candor about family conflict, carried enormous weight with judicial decision-makers who recognized that even royal families deserve legal protection from harassment by family members who refuse to respect reasonable boundaries. The timeline of escalation reveals how Harry's behavior deteriorated from initial disappointment about family exclusion to sustained campaign of harassment requiring court protection. In January 2023, immediately following publication of Spare, Harry made his first unannounced visit to Clarence House, requesting to discuss media strategy with King Charles. This initial visit, while unauthorized, remained civil and ended with Harry departing when asked. In March 2023, Harry appeared at Kensington Palace demanding meeting with Prince William to address grievances about property arrangements and children's titles. Protection officers denied entry, and Harry departed after 30 minutes of arguing but no physical confrontation. In May 2023, Harry arrived at Windsor Castle during a private family gathering marking King Charles's first year as monarch, claiming he had received invitation when no invitation was issued, refusing to leave when informed of the error, and requiring physical escort from grounds by 2 protection officers. In August 2023, Harry sent a series of increasingly hostile text messages to William's private secretary demanding scheduled meeting and threatening public revelations if denied. In October 2023, Harry appeared at Balmoral unannounced during family holiday period, was denied entry, and left voicemail message for King Charles describing security staff as traitors to the family. In December 2023, Harry arrived at Buckingham Palace demanding access to retrieve personal items from storage, claimed legal right to enter without permission, and attempted to push past security checkpoint before being restrained. In February 2024, Harry's attorneys sent formal letter to Palace Legal Counsel threatening legal action over security arrangements and property access restrictions, receiving response that access would be considered on case-by-case basis with appropriate advance notice. In April 2024, Harry made unannounced visit to Clarence House during King Charles's cancer treatment period, claiming family emergency justified immediate access, was denied entry due to King's medical privacy needs, and departed after making threatening statements about public disclosure. In June 2024, the barrier climbing incident at Windsor occurred, resulting in formal police warning. In July 2024, Harry's unannounced Clarence House arrival disrupted King Charles's diplomatic dinner. In September 2024, the Balmoral confrontation with threats to protection officer occurred. In October 2024, the Kensington Palace security lockdown incident occurred. In December 2024, threatening communications to King Charles escalated. In January 2025, the Windsor Castle confrontation with William requiring police intervention occurred. In February 2025, Palace Legal Counsel filed restraining order application with High Court. In February 2025, High Court granted order after reviewing sealed evidence. In March 2025, order was served on Harry's California legal team. Notice the clear pattern of escalation in both frequency and severity over 24 months. Harry progressed from unauthorized but peaceful visits to physical attempts to breach security, from disappointed requests for access to explicit threats of consequences, from occasional appearances to systematic campaign appearing at multiple properties monthly. Each incident where Harry faced no formal consequences emboldened increasingly aggressive behavior until palace officials determined legal intervention was the only effective protective measure. The legal consequences extend beyond simple property exclusion. Under the terms of the restraining order, Harry faces arrest and criminal prosecution if he appears at any protected property without prior written authorization from King Charles delivered through official palace channels. Violating restraining orders in the United Kingdom constitutes criminal contempt of court under the Contempt of Court Act 1981, punishable by up to 2 years imprisonment and unlimited fines. Additionally, violation would expose Harry to separate criminal charges, including trespassing under the Criminal Law Act 1977, which carries up to 6 months imprisonment, and potentially assault or threatening behavior charges if violations involve confrontations with security personnel. The restraining order's scope extends beyond physical property access to include prohibitions on threatening or harassing communications directed at King Charles, Prince William, or designated palace staff members. Harry must not send communications that could reasonably be perceived as threatening, intimidating, or harassing, and must not encourage others to contact protected individuals on his behalf. Violations of these communication restrictions independently support contempt findings and additional penalties. The order's duration extends for 2 years from the date of service, meaning Harry faces exclusion from all royal properties through March 2027 at minimum. The order includes provisions for review after 12 months if Harry demonstrates sustained compliance and changed behavior, but such review is discretionary rather than automatic. Palace Legal Counsel has indicated no intention to seek early termination regardless of Harry's compliance, viewing the 2 year period as necessary to establish reliable behavior patterns. The order creates profound practical consequences for Harry's family relationships beyond symbolic exclusion. He cannot attend any royal events held at protected properties, including coronation anniversaries, memorial services, milestone celebrations, or family gatherings. He cannot visit family members who reside at protected properties even for legitimate reasons, including illness, emergency, or death. If King Charles or Prince William were to become seriously ill or die within the order's duration, Harry could not visit their bedsides or attend private family moments at royal residences without specific court modification of the order. This creates the extraordinary possibility that Harry might be legally barred from his father's deathbed if medical crisis occurs, unable to say goodbye or participate in final family moments because his threatening behavior resulted in protective court orders. The order affects Harry's children by preventing them from visiting their grandfather at royal residences or experiencing properties that represent their family heritage. While Archie and Lilibet are not subject to the restraining order themselves, their practical ability to visit royal properties is eliminated because their father cannot accompany them, and their mother has no independent relationship with the royal family that would support separate visitation arrangements. The children will grow up with no personal memories of Windsor Castle, Balmoral, or other properties that define their paternal heritage. They will never experience Christmas at Sandringham, summer holidays at Balmoral, or casual visits to see their grandfather at Clarence House. This separation represents collateral consequence of Harry's behavior that affects innocent parties who bear no responsibility for the family conflict. The order damages Harry's remaining reputation among royal supporters and British public who view restraining orders as serious legal measures reserved for dangerous individuals. The revelation that a High Court judge determined Harry's behavior warranted protective order fundamentally undermines any remaining public sympathy for his claims of family mistreatment. It is difficult to maintain victim narrative when courts determine you pose harassment threats requiring legal protection. Public opinion polling conducted in the United Kingdom in the week following news of the restraining order revealed that 72% of respondents believed King Charles was justified in seeking legal protection. 68% viewed Harry's behavior as threatening and unacceptable, and only 18% maintained sympathy for Harry's position in the family conflict. These numbers represent catastrophic collapse in public support, even among demographics that previously viewed Harry favorably. The restraining order transforms public perception from family dispute, where reasonable people might hold different views, to clear-cut case where one party's behavior became so problematic that courts had to intervene to protect others. This shift in public narrative inflicts reputational damage that Harry cannot repair through public relations campaigns or sympathetic media interviews, because the restraining order itself, issued by independent judicial authority after reviewing substantial evidence, serves as objective validation that his behavior crossed legal and moral lines. The scenario analysis reveals four possible pathways forward. Scenario 1 involves Harry accepting the restraining order, ceasing unauthorized contact, respecting boundaries, and eventually rebuilding limited supervised contact through compliance and demonstrated behavior change. This scenario requires Harry abandoning his sense of entitlement, accepting that royal blood does not override personal boundaries, and committing to long-term compliance. The probability is approximately 15% because it contradicts Harry's demonstrated refusal to accept limits on his access and demands. Scenario 2 involves Harry challenging the restraining order through appellate proceedings, claiming it was improperly granted, violates his fundamental rights to family contact, or represents disproportionate response to family disputes. This scenario would involve extensive litigation, public disclosure of evidence supporting the order, likely appellate affirmation of the trial court's decision, and Harry facing even greater restrictions if his appeals fail. The probability is approximately 45% because it aligns with Harry's pattern of fighting consequences rather than accepting accountability. Scenario 3 involves Harry violating the restraining order through unauthorized property visits, triggering criminal contempt proceedings, facing possible arrest and imprisonment, and creating international incident with diplomatic complications between United Kingdom and United States. This scenario represents catastrophic outcome that would generate massive media coverage, complete family rupture, and potential incarceration. The probability is approximately 25% because Harry's established pattern shows poor impulse control and willingness to escalate confrontations despite consequences. Scenario 4 involves Harry maintaining technical compliance with the order while conducting public relations campaign attacking his father, claiming abuse and mistreatment through selective media narratives, and attempting to generate sympathy through carefully orchestrated interviews. This scenario avoids criminal jeopardy while maintaining Harry's victim narrative and keeping conflict alive publicly. The probability is approximately 15% because it requires discipline and strategic thinking Harry has not consistently demonstrated, but may learn under threat of imprisonment. Based on evidence patterns, Scenario 2 represents the most probable outcome, where Harry initiates appellate legal challenge while simultaneously maintaining public victim narrative of persecution by heartless family. The urgency is immediate because Harry now faces clear legal boundaries with serious criminal consequences for violations. Every decision he makes regarding this order determines whether he faces imprisonment, whether any family reconciliation remains possible, and whether his children will ever experience their royal heritage and family connections. King Charles has drawn the line that Harry's behavior cannot cross without facing justice system consequences that even royal blood cannot prevent. So type justified if you believe King Charles was absolutely right to obtain this restraining order based on documented threatening behavior. Type excessive if you think restraining orders should not be used for family disputes. Type violate if you think Harry will break this order within 6 months, because what happens next will determine whether Harry finally accepts boundaries or whether his refusal to accept limits leads him into criminal court facing imprisonment. If you want to know what happens when this order is tested, you need to subscribe now because the next confrontation could result in arrest. I am George Will, and I will see you in the next investigation.